Good afternoon, everyone. My name is John Cornwell, and I'm the Director of Marketing and Business Development here at Plunkett Cooney. It's my pleasure to serve as coordinator for today's call and webinar. So please do what you can to get engaged in this conversation. It's certainly a very popular one from what the questions are that we've been receiving. And we're pleased to have the members of our Labor and Employment Practice Group sponsor this event, which is part of our Sophisticated Employer webinar series. And in light of Governor Whitmer's Executive Order 2020-77, many manufacturing companies have returned employees to the workplace effective May 11th. Our hope is that employers in other industries will also be able to start returning employees back to work in the very near future. So that's why we're taking time out today to explore how this can be done safely and in accordance with best practices as put forth by our scientific and medical communities. Fortunately, we have with us today three members of Plunkett Cooney's Labor and Employment Law Practice Group: Laura Dinan, Courtney Nichols, and Claudia Orr, all of whom have been studying this important back-to-work process. But before we get started, as I tend to do on these webinars, I want to just take a couple minutes and tell you a little bit about our firm. For those of you who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with approximately 140 attorneys. We have offices in 7 Michigan cities, as well as in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Our employment law practice group includes more than 20 attorneys who work in the areas of traditional labor law, human resources consulting, employment litigation, and even workers' compensation. Our Sophisticated Employer webinar series is designed to help human resources professionals, risk managers, and business executives stay up to date on important issues and to provide HR best practices, as well as to discuss trends in workforce management. As I mentioned, we're joined today by 3 of the firm's top employment law attorneys, and their images are now up on the screen. So welcome, everybody, all of our speakers today. I want to give just a little bit of background before them, and then I'll turn over the program. First up is Laura Dinan, who has over 30 years of experience advising employers. She's built a successful practice representing public and private sector employers of all sizes throughout northern Michigan. Laura's expertise includes traditional labor and all types of employment law matters. She's a past president and currently the secretary of the board of directors of the Northern Michigan Society of Human Resource Directors. Courtney Nichols serves as co-leader of the firm's Labor and Employment Law Practice Group. She focuses her litigation practice in the areas of employment law, including discrimination, retaliation, and civil rights claims brought under state and federal statutes. Courtney also provides counsel to employers of all sizes regarding complicated employment and labor issues prior to litigation, including compliance with the ADA, FMLA, and the FLSA. And lastly, Claudia Orr. She has nearly 30 years of experience representing employers ranging from Fortune 500 companies to small businesses and nonprofits. Claudia provides advice on all aspects of employment law and defends her clients when litigation and administrative issues arise. She regularly serves as an arbitrator and as a mediator in employment law cases. And Claudia is serving as a member of the board of directors of Detroit SHRM for the second time around, this time as secretary. She also remains a member of the organization's Legal Affairs Committee. Now, a couple quick housekeeping notes about today's program. For the Q&A portion of our webinar, we'll use our questions widget on your GoToWebinar navigation display. Please take a moment now to locate that widget and feel free to enter questions as they occur to you during the program. At the end of the presentation, we'll try to answer as many as time permits, and we only ask that you pose questions of a more general nature versus getting into specifics about your actual workplace. Finally, I want to mention that today's session is being recorded and that recording is going to be available on our event page on Plunkett Cooney's website, which is located at plunkettcooney.com. Feel free to share that link or direct colleagues to that page. And thanks again to everybody for attending today. I'm excited about the program, and now it's time to turn it over to our presenters. Courtney, I believe you are leading off today, so please take it away.
Yes, I am. Thank you, John, and thank you, everybody, for joining the webinar with us today. There's a lot of information to cover, and we're going to try to get right into it. We did want to address some questions, so we asked for questions in advance that we've tried to incorporate into this presentation where applicable. We're going to have some questions at the end of the prepared materials, And then we're also going to give attendees a chance to ask questions during the presentation. So if you do have a question, please, as noted, put it in, and so we can take a chance to answer it. And to the extent we can't get through all the questions today, we will certainly try to follow up with attendees after the presentation. So with that, we will start with, again, a quick summary of what we're going to be talking about today. The applicable Michigan executive orders, primary concerns when resuming in-person business activities, some administrative guidance that we've gotten recently, and of course, answering your questions, which is our primary purpose when discussing getting employees back to work. So the topic of the week, so to speak, has been Executive Order 2020-77. So this was the executive order that was issued last week that added on to the previous orders, rescinded Executive Order 2020-70, and allowed manufacturing companies to reopen subject to the restrictions and requirements within that order. So if you haven't seen 2020-77, please pull up the actual order. You can get it from the government website and download it. I want to talk to you briefly about some of the key takeaways. This is not a webinar dedicated to getting into the minutia, but we do want to address it. If you have any particular questions, again, feel free to ask. Generally, there are new categories of businesses that can now conduct in-person work. So originally, everybody was told to stay home unless you were a critical infrastructure worker or what we call essential employees or necessary to conduct minimum basic business operations. That has since expanded, and we've gotten resumed activities. So some key resumed activities from 77 are workers who are necessary to train, credential, and license first responders and healthcare workers, workers that are necessary to perform startup activities at manufacturing facilities, including activities necessary to allow those facilities to implement workplace safeguards, and workers necessary to perform manufacturing activities subject to the safeguards. So again, this is in addition to the previous executive orders. Now, the key issue here is manufacturing activities, because we know that is such a significant portion of our Michigan economy. So what does it mean when we're talking about resumed manufacturing activities, and what limitations do we have? So the limitations that are really applicable here, we're going to address them in turn. The first one is the most pressing limitation, in my opinion, and something that we've received a lot of questions about, and this is the daily screening protocol. So to resume manufacturing activities, you've got to make sure that you're conducting a daily entry screening protocol for all workers, contractors, suppliers, and anyone else entering the facility. So this includes a questionnaire covering the symptoms and suspected or confirmed exposure to people with possible COVID-19, and a temperature screening, so long as the no-touch thermometers are available. And if they're not available, you've got to implement that as soon as no-touch thermometers can be obtained. So the key here is temperature screening as soon as you can get those no-touch thermometers. If you have them, there's no excuse not to be doing right away, or other mechanisms of screening temperatures. But this is the number one question that I've gotten about the daily entry, which is, does that mean we have to do a temperature check? And for the resumed manufacturing activities as they sit today, yes, if you have the touchless thermometers, and if you don't, you have to start working at getting those so that you can implement that process as soon as possible. There has to be a dedicated entry point at every facility, and you have to make sure that there are physical barriers in place to prevent people from trying to skirt that entry point and get into the facility without the proper screening. These are the questions. So when we get into the daily screening questions, and there can be slight variances as it relates to these questions, but these are the ones that we've seen most companies use or utilize in some fashion, which is, have you been in close contact with a confirmed case of COVID-19 within the past 14 days? That can be, however you want to define close contact is generally something very close to this, within 3 to 6 feet for 15 minutes or longer. If somebody's asking what close contact means, if you want to define it, again, within 3 to 6 feet for 15 minutes or longer. Have you had a fever or felt feverish in the last 72 hours? Are you experiencing any new respiratory symptoms, including a runny nose, sore throat, cough, or shortness of breath? Are you experiencing any new muscle aches or chills? Have you experienced any new change in your sense of taste and smell? Or have you traveled on an airplane internationally or domestically? Now, again, some of these questions might be slightly varied. Some companies are doing a more broad approach, and the travel question, for example, might just be, have you traveled internationally or domestically outside of the state of Michigan, other than for your normal daily commute within the past 14 days? That might necessarily encompass some people that have driven, for example, to a state like New York. That might be more of a problem and allow for more broad screening. But you will see some of these screening questionnaires on various websites. It's really important to implement questions that are going to be applicable to your workplace while addressing generally three things. Have you been exposed to somebody with COVID-19? Have you been symptomatic or diagnosed with COVID-19? And have you traveled someplace that might put you at a high risk for COVID-19? So those are the type of screening questions that we want to address in the questionnaires. The temperature check. Again, you have to make temperatures, have to take the temperatures as soon as touchless thermometers are available. Okay, so it doesn't address temperature screening with non-touchless thermometers, but the goal of all of these measures is to ensure social distancing and avoid spreading this virus any further than it's already been spread. So regular thermometers are inherently problematic because you're exchanging saliva, you're passing it back and forth. So touchless is really the key here. Again, we all know that it's been very difficult to get touchless thermometers, and the government is going to be working with businesses that might not have been able to get their supply in the door yet, but you've got to show that you've taken measures to try to get that the touchless thermometers necessary to do the daily screening. The construction industry, as it relates to their operations, it says that they should, if possible, take temperatures. So that's a different language than as it relates to manufacturing, and that's an intentional difference. Construction is a bit more relaxed than manufacturing, where there's going to be more stringent requirements. With that said, where you are operating, you should check to see if there are county-specific orders in place. I didn't want to spend a lot of time getting into all the various counties we have in Michigan during our presentation today, but there are some counties that may require temperature checks as well. Oakland, Macomb, Wayne, you want to be tracking those health department orders to make sure that you're compliant with your county-specific requirements. So again, moving on, what else do you have to do to resume manufacturing activities? These are the requirements. Suspend all non-essential in-person visits, including tours. You can't just have people walking through the facilities. You have to provide training. So these are the things that you have to train employees regarding: transmission of COVID-19, the symptoms, how to use PPE, and preventative rules that the company is implementing. What most companies are doing is a game plan. So you will see some companies that have already advertised their game plans. Ford, Lear, some of the bigger Michigan employers, which are great starting points for companies to look at to try to see what some of the big entities are doing in the area. It doesn't mean that you have to provide a week-long training program. It means that you've got to give employees information sufficient to familiarize them with what this disease is, how it's spread, and what you're doing to stop it. So these are just some training suggestions. Webinars, a quick program like we're doing today over lunch, where you have everybody log in and do a 1-hour webinar. Pre-shift training before everybody's getting on board, whether you do it every day for a week or once a week, some way that you're training and you're documenting that this training is occurring. Written materials. If you're disseminating written materials, your return to work playbook or your return to work guide, that's great. We want to make sure that employees are acknowledging receipt of those materials. They're signing off that they have them. They're transmitted in a way that we can track it so that we avoid an employee claiming down the line that he or she did not get that material. No matter what you do, make sure it's 100% accurate. So I'm sure you've heard me say this on other webinars, but a bad policy that is not accurate with what you're doing is probably worse than no policy at all, because it's going to make all of your other policies look meaningless. So please, if you're borrowing a plan or if you're trying to get something implemented, make sure that your management, that your C-suite, that every level of the organization has bought in and knows to comply with that plan. Beyond training, you are also required to take some social distancing measures, is the easiest way I could describe it. Reduce congestion in common spaces, implement rotational shift schedules when possible, again, trying to limit the number of people in the plant or facility at any given time. Stagger start times and meal times. That's particularly important when you're doing pre-shift screening, because the last thing you want is 100 people showing up to the same area at the exact same time for screening. So if we can stagger those start times by even 15, 10 minutes to try to avoid that mass arrival or mass exodus, that is helpful. Meal times as well. Again, the physical barriers, they're necessary as it relates to the initial screening and making sure that we don't have people avoiding the screening points. The order says that it's practically recommended. So it's something that should be implemented if possible between workstations and cafeteria tables. Again, trying to isolate people congesting in particular areas. Same things on this slide, right? You're trying to minimize personal contact, limiting sharing of tools and equipment. That's not going to mean you can't share tools and equipment. Obviously, that maximum extent possible language is in there for a reason. And disinfecting. Now, what does frequently mean? There's no definition. It's going to depend on the nature of your business. As much as possible is probably the way the government would like to enforce this, but we're encouraging companies to take a look at your high-touch surfaces, the areas where you're going to have a lot of people in a short amount of time, and figure out how frequently can we clean that, what products can we use, how can we make sure that we're not spreading the virus using those particular areas. Some more, I'm not going to get into all of these. Again, the executive order is the best source of information, but the few things here that are critical really, in my opinion, relate to making sure employees know their obligations. So again, this gets to a return to work game plan or process or procedure. But we want to make sure that employees know not only what we're doing as a company, but what they're going to be obligated to do. Because you do have to require your employees to not only buy into the new processes, but to report. So there's daily screening where we need them to be accurately reporting symptoms. And there's also the requirement that they self-report to plant leaders, to management, to human resources as soon as possible if they become symptomatic or if there are areas of the workplace that are not compliant with this executive order. Then if we continue on, after we make sure that all of our resumed manufacturing activities are in place, we get to the FAQs. So this whole concept of necessary. Now, again, the executive order does not say all manufacturing is free to open, carte blanche, have at it, let's go. The intent is to open the manufacturing industry without destroying the progress that has been made thus far relative to flattening the curve, okay? So that's why there's the word necessary. Workers necessary to resume manufacturing operations. The order is to be construed to the broadest extent possible to prohibit in-person work. So while the government certainly wants manufacturing to reopen, they don't want there to be people just at work for no other reason than to be there. Okay, if there's not a need for them to be in person and performing that work, then we need to tread very carefully. Again, the more people you have coming at one time, the greater chance of exposure, which could then result in a plant shutdown and significantly impact your operations. So we are telling everybody to be really diligent when you're assessing who's necessary for in-person work at this time, and to be able to explain that in writing if you're ever called to answer the question as to why you have this number of people in the plant for this particular activity. Do I think that's likely? Do I think that local law enforcement officers are going to be trying to shut down manufacturing plants? I don't, but I do think it's in the best interest of employers to be prepared and ready to go. And I also think it's in the best interest of your employees for you to be able to explain that to them as well. Same question here that I think I touched on, but it relates to the touchless thermometers. You have a couple and you have several hundred employees. The way the order reads, the governor's office has made it very clear that you're to use touchless thermometers if available. So if you have two available, I would try to use those in the areas that are most populated and screen as many people as possible. Again, the goal is to do the best you can with what you have right now and to try to get more as soon as possible. As it relates to how you record the screening questions, I have had clients ask me, can we use Paychecks? Can we use ADP? Can we use Google Docs to keep all of the screening questionnaires and the information we get about employees who are symptomatic? I would caution you against that just because we have seen data breaches and potential exposure with data being lost when you're using a third-party app or platform. I like internal spreadsheets and hard copy documents because that way we know that they've been saved appropriately and they can be printed and locked away in a nice locked drawer. Again, if efficiency requires that you use Google Docs or something like that, it's not prohibited. Just make sure that you've taken steps to ensure the security of that information. As it relates to letters to employees who are coming back for resumed manufacturing activity, you do not have to give them a letter to carry around with them. So if they're stopped by the Oakland County Sheriff, they can explain that they are a manufacturing employee. However, you do need to provide them with some sort of notice, written acknowledgement. It can be an email, it can be a letter, that they have been deemed an employee who is necessary to come to work to resume manufacturing activity. So just something as simple as, we've called you back to work in compliance with Executive Order 2020-77 is perfectly fine. They don't need a letter to carry around with them. So with that, I want to hand it to Laura to now talk about some EEOC guidance that we have received recently.
Thanks, Courtney. We're, again, just as Courtney directed you to the executive order, I'm going to refer you to the latest EEOC guidance, what you should know about the ADA Rehabilitation Act and coronavirus. This is, as you may be familiar with, the EEOC and the Department of Labor are sort of putting out running guidances. They go back and update as we learn new things and as they have different interpretations. So this is a living document, but it's a really good resource for you to go on and check to find answers to some of your questions. Last week on Tuesday, they put out an update and they pulled it down on Wednesday and reissued it on Thursday because they were upset about how some people were interpreting it. So it's very updated as of this point in time. It's about 4 days old. They elaborated on advice for disability accommodation requests and harassment, and they did add a section regarding returning employees to work after the pandemic. So you might want to look at this right after, while this information is fresh in your mind. One thing they've made clear throughout this, and it's reinforced in this guidance, is that the EEOC laws that they enforce, including the Americans with Disability Act and the Rehabilitation Act, still apply during the pandemic. However, they don't prevent people from, or employers from, still following the guidelines and suggestions from the CDC and your local or state, so the state executive orders and the local public health orders. So honestly, the EEOC is kind of taking a back seat, if you will. They're still going to enforce them. The regular rules apply, but they understand that under these circumstances, there might be some clash between state and local orders, and they are telling you to still follow those state and local orders. So if you're trying to do the right thing and it might not work out exactly as the EEOC would normally like to see it, you're probably still going to be okay if you can point to the state or local order that you were trying to comply with or were complying with. And one of these areas is the critical infrastructure and essential critical workers are still covered by the ADA and the Rehab Act. So most of you probably know, if it affects you, that under the governor's executive orders in Michigan, many of the things, protections she's put in place, keeping people home, etc., do not, they give the employer the option, if you're a healthcare employer or in, like a municipality, somebody that employs essential critical workers, your workers may not have the same rules applicable to them regarding ability to take advantage of the Paid Sick Leave Act, or some of the protections out there don't apply to healthcare workers, but the ADA and the Rehab Act still do. So we've had circumstances where an employer is allowed to tell an employee that they have to come to work regardless of some of the new rules that are put in place that might let them stay home to take care of someone who has COVID-19, And they've been able to come back and say, well, I'm protected by the ADA. And that might be a bad connection example there. I'm sorry, I'm drawing a blank. But so even if they're exempted under a state or even a federal law, the ADA and the Rehab Act might cover them. So you have to consider that when you're assessing a request or how to handle bringing back or keeping someone out of the workplace. The ADA allows employers to make disability-related inquiries and conduct medical exams if they are job-related and consistent with business necessity. They have basically, and it also allows employers to exclude employees with a medical condition that would pose a direct threat to health or safety. And they basically determined that COVID-19 is such a condition. Therefore, all of these screening questions that you're asking at the start of shifts or are going to be asking, the temperature taking, the requiring tests of some employees, that is all, they in normal times might be violations of the ADA, but because individuals with COVID-19 present a direct threat to others in the workplace, those types of screening things are okay right now, according to the EEOC. So if an employee, we're getting a lot of questions about protecting vulnerable employees coming back into the workplace and also employees who don't want to return, and they're going to be addressed later in this. But basically, if an employee doesn't ask for a reasonable accommodation, then the employer doesn't have to do anything or take any action. So if you have people that you know are vulnerable, but they don't bring it to your attention, don't ask for any kind of accommodation, you can just allow them to come back into the workplace. And again, we're going to address it a little more in depth in a minute, but if you as the employer believe you have an employee who returning to work or at work might be a direct threat to their own well-being or that of others, you have to go through the direct threat analysis. And many of you are probably familiar with this in with other conditions, not COVID-19, but it's a high standard to show that direct threat. You have to do an individualized assessment based on relevant factors, and you have to make a determination whether the threat can be reduced or eliminated through a reasonable accommodation. And keep in mind always when we're talking reasonable accommodations, you're referring to something that allows the person to perform all the essential functions of their job. So if a person poses a direct threat to their health that can't be eliminated or reduced by a reasonable accommodation, you could exclude them from the workplace, put them on a leave because of the direct threat that's posed if they're in the workplace. And the same if they, for instance, this is pretty obvious, but if they have COVID-19, they are a direct threat to the health and safety of others, and they can be prevented from being in the workplace. But that isn't actually an ADA analysis because COVID-19 in general is not a disability under the ADA. But that people have other conditions that tie it into the direct threat and the COVID-19 analysis. So when you're doing the direct threat, you consider the severity of the potential harm to the worker, the chances that the harm will occur, the likelihood that a person will be exposed to COVID-19 at work, and the potential impact of any protective measures the employer is taking to protect the workplace as a whole. Even if a direct threat exists, you can't bar the employee from work unless there's no way to provide a reasonable accommodation that isn't an undue hardship. So sometimes if you can put them in another work area, isolate them, remote working wouldn't be in the workplace, but you have to go through all the potential accommodations that might be available to mitigate the direct threat issue before you can keep them out of the workplace. So the other area that the EEOC is pretty concerned with right now is harassment, specifically race or national origin. There have been a lot of comments made at the national level that have been in the news, blaming Asians and Chinese in particular from bringing, everything from creating COVID-19 to bringing it here to spreading it, blah, blah, blah. But it has caused an uptick in actions, harassment against Asians. And the CDC is warning that prejudice against Asians is out there and it's not allowed, and that Asians are no more likely to be bringing this, spreading this in the workplace than anyone else, with the exception of people that may have traveled to China. But in general, they don't have any greater ability to spread it than anyone else. So employers need, especially as you return people to work, to closely monitor any concerns that are expressed to you or anything you observe. Train your supervisors. You have to be concerned with disparate treatment or harassment because of national origin in the workplace. And this could be, direct harassment, bullying, that type of thing. And it can also be employees avoiding certain other employees, kind of a shunning kind of thing. So be alert to it and train your supervisors and managers that this is an issue and they need to be alert to it, and you need to head it off right away if it's occurring. And you can, as I alluded to, you can ban an employee from the workplace if they were recently in China, the 14-day self-quarantine for travel out of the country, travel on an airplane, travel to a hot spot, or if they have the symptoms or, have been exposed, but you're basically treating them the way you would any other employee who did any of those things. So you're choosing to ban that due to the objective reasons, not because they're perhaps Asian. Next slide, John. So some of the questions that we've gotten are, and there's going to be some overlap, I think, between all three of us, but I think it bears reinforcing. When should we require our employees to be tested or perform on-site testing of employees? And the general recognition and recommendation is that it's not going to be realistic at this point in time, at least, to be able to test all of your employees, and it's not going to be practical. And so the general rule is that if they flunk the symptom screening and then you take their temperature and they flunk that, then those individuals are the ones who should be tested if you have testing capability, and hopefully you can get it to address it with those employees. The next one talked about a little bit, how do you ensure the safety of vulnerable workers without engaging in unlawful age or disability discrimination, which is another area that the EEOC is watching carefully. And this is a tough one because a lot of employers want to do the right thing and protect the people that fall into the vulnerable category as identified by the CDC, which can be anything from underlying conditions like asthma, diabetes, heart conditions, cancer, chemo status, elderly, but you can't, as an employer, reach out and pick out those people to protect. It's almost as bad as it's a bad thing, sorry. So the best practice is that if the vulnerable people come to you asking for protection, then you go through the ADA direct threat. Are they vulnerable? Is there a threat to them returning them to the workplace? And you can go through the analysis and try to provide a reasonable accommodation. But if they don't come to you and ask, you can't really be proactive. I kind of like to compare this to a police officer. I'll get a call from a police chief that he's got a pregnant officer and he's really concerned that she's out on the street and wants to put her on a desk job or keep her out of the workplace. And you can't do that unless the employee asks for it. An employer is not supposed to be proactive in protecting their employees when it could be or for a protected reason if they fall into a protected category. And generally, you want to protect all your employees, but you can't single people out due to their protected status unless they ask for that. The primary harassment concerns regarding COVID-19 are, as I just talked about, national origin and race, particularly Asian. I suspect that there may be, as you return big groups of people to the workforce, that there may be some backlash and harassment arising against people who've actually had the disease or people that other employees view as carriers or not being careful enough. And so I think that employers are going to need to be watchful about those types of issues also. So where do you keep the screening results? Courtney talked a little bit about that. They are medical tests under HIPAA, and so they have to be kept in a separate file. Again, I agree with Courtney totally that paper files, hard copies are the best way to go. And I think the best way to do it is just add it to the employee's actual medical file. I do think you could also have a COVID-19 screening file, if you will, for the screening tests on a daily basis. If a person exhibits symptoms and or flunks a temperature test or a COVID-19 test, that information definitely should go in a file specific to the individual employee, into their regular medical file. You have to have that separate medical file, but I don't think you have to have a separate file for each issue. So the COVID-19 things can all go into one file, but it's the medical file and it needs to be kept confidential and locked. Can you disclose the name of an employee to a public health agency when you learn the employee has tested positive? Yes, you can. It's required under the public health laws. They will follow up with contact tracing, and it's protected under executive orders and the general public health rules. That's one of the few exceptions to HIPAA. You can disclose that information. And what if an employee voluntarily sends a message to other employees about his or her exposure to COVID-19? You can't discipline them. Again, I don't know how many people are going to be out there doing it. I think that could be a cause that people may be subjected to some distancing and or harassment type behavior if they do that. It's I don't think you should really approach the person who did it. It's going to generate concerns that are going to come back to you, and all you're going to be able to do, I think, is tell people that you are taking every precaution, point to your sanitization, your social distancing, and your doctor notes, whatever, return to work requirements before a person can come back in the workplace, and so you don't believe there's any threat to anybody based on that, if people come to you, but I don't think you put out any general kind of communication regarding it. Now I am going to turn it over to Claudia to talk about the OSHA requirements.
Thanks, Laurel. So we're going to run through the OSHA stuff pretty quickly. There's some websites for you to check in on that are handy links for your use. But in general, OSHA guidance reflects a lot of the executive order stuff, requiring social distancing of 6 feet between workstations, establishing flexible work hours, staggered shifts, discouraging shared use of phones and tools, and so on. Encouraging telecommuting whenever it's still feasible to limit the worksite exposures, and to train workers on how to properly use their personal protective equipment. Keep in mind that there's a great chance for exposure if you're not taking them off correctly, because now you've got this equipment that may have been exposed. And if you're handling the gloves, for instance, on the outside with that hand that you already took the other glove off with, you just contaminated yourself. The guidance also talks about training the workers on how to use this, requires employees to stay away from the workplace if they're ill, requires workers to wear face coverings and masks, unless there's an ADA issue, like maybe they have COPD or something. Monitor public health communications, see what's going on, make sure that you pass this stuff on to your employees. Promote coughing and sneezing, proper etiquette, washing your hands frequently for 20 seconds. If you remember the song, if they're dirty and you know it, wash your hands. That actually will take you through the 20 seconds. You can also use, make sure you provide disinfectants, disposable towels to clean stuff, encourage workers to report any safety or health concerns. So, I mean, it's a lot of the same stuff that's in the executive order. So moving on to whether it's a recordable or reportable incident, well, it depends. If your company has 10 or less employees at all times during the last year, then generally you don't have to do any reporting or keep records of injuries and illnesses unless you've been told in writing by OSHA and the Bureau of Labor Statistics to do so. But all employers who are covered by OSHA must report anything that results in a fatality at work or inpatient hospitalization, amputation, or the loss of an eye. So more specifically, when is COVID-19 a recordable illness? Well, if it's a confirmed case, not just a suspected case. If it's work-related, that's the big one. There's now a presumption under our workers' comp rules in Michigan that if you're a healthcare provider, that it was work-related. And also, if it involves one or more of the general recording criteria, which is, like deaths, days away from work, which probably is the most likely one, restricted work or transfer to another job, medical treatment beyond first aid, loss of consciousness, or some other significant injury or illness that's been diagnosed. The next screen has a decision tree for you to look at. Use it if you find it helpful. We're not going to review it, but it's theirs in the materials if you want to use it in the future. As far as OSHA, how is it enforcing things? What does it look like during a pandemic? Well, if there's fatalities and there's guidance, again, you can click on the link. Fatalities and imminent danger exposures are going to be prioritized for investigation. If there's a formal complaint, whether it's that means it's been signed and it's written, and it alleges that there's been unprotected exposures by employees in high or very high risk jobs like at hospitals or clinics, then that may warrant an on-site inspection. Other workplaces, typically it won't result in an on-site inspection at this time because they're pretty busy these days. And then everything else is generally non-formal. And one of my clients recently received a OSHA complaint, and I wanted to keep it casual. If the attorney gets involved, then it tends to up things. So I wrote out a 4 or 5 sentence response for my client to cut and paste and sent it in an email back to the investigator. And within 5 minutes, it was dismissed. So some practical considerations under OSHA. Generally, OSHA requires employers to conduct hazard assessments and isolate sick employees. So let's look at some of the issues, practical issues under the physical environment, traffic, and scheduling and sick employees. So get your pens ready because I'm going to run through those three topics pretty quick. And my goal is just to provide you with some ideas to think about that, oh yeah, I hadn't thought about that. I guess we need to take a look at that. Courtney's already addressed manufacturers, so I'm going to be talking more about, office settings, although a lot of this will cross over. So for example, our Detroit office is kind of a big square. Maybe you want to consider one-way hallways that people aren't passing each other in the halls. Are you going to allow employees to use refrigerators with everyone's lunch boxes and Tupperware brought in from home? What about the coffee and pop and ice machines, especially those ice machines where you scoop in with your hand, with a little scoop to get in there? What about, do you want to purchase some touchless garbage cans or no-touch hand sanitizers? Do you want to make it available hand sanitizers, little ones for the employees, so that when they leave the office, but before they enter their car and start touching their personal stuff, that they can make sure that their hands are clean? Because remember, they touch the elevators on the way down. What about the air circulation or air ducts or filters if you actually control the environment? What about your smoking or picnic areas? People are going to be wanting to be outside, so you're going to have to monitor and make sure that people aren't all standing around that picnic table and smoking. What about the stairwell railings or the supply cabinets that people are going in and out of? And of course, you got the tools and copiers that present additional risks. What about traffic and scheduling ideas? Courtney mentioned, staggering shifts to prevent everybody coming and going at the same time. What about actually leaving some time between the shifts that you can do some deeper cleaning, or flexing the start and finish of lunches? The employees don't all come and go at once or all want to sit in the cafeteria at the same time. Or what about having a rule that prohibits employees from setting foot in another person's office? Or what about even isolating functional areas like finance? Only finance employees are in there, and if somebody needs something from finance, they use the phone. What about your guests? You're going to have PPE for them as well, and not just guests. What about the daily deliveries you receive of copy paper and supplies and so on, or messengers from other companies? How's that going to be handled? And how are you going to protect your employees who deliver elsewhere or go to another business? I mean, it could be that customers are going to require screening of your employees or testing even before your employees are allowed back at their work site. And then sick employees, not just the daily health screening mentioned by Courtney, but are you actually going to require COVID-19 testing before employees come back? Well, if the tests are available, maybe, especially if your employees are working with vulnerable consumers, like an elderly population. What about the daily health screening? How are you going to conduct them? Are you going to have like a supervisor there and an iPad and they're typing stuff in, or the paper stuff? But you need to document it. And what about the employee when they get sick? You need to have a plan on who that employee notifies. And obviously, if they leave, you're going to have to track potential exposures. Who else came into contact with them? Are you going to quarantine those employees for 14 days? What about a deep clean of that office area and isolating it before that can be completed to make sure other people aren't going in there? So these are just a few of the practical issues that you need to consider that more closely related to your own workplace. Next screen. So how we're going to switch gears. We're going to talk about bringing employees back to work. So next screen. Who gets called back? Are you going to do it all at once? Are you going to do it in waves such that maybe the maintenance people come back and get things ready, and then the office services people, and then are you going to put in? One of my clients has set up pods or like practicing groups. So for example, maybe you have a social worker, a case manager, and a peer support person. You can kind of do a lot of nonprofit work. Maybe they're a team. Are you going to just start bringing in one team at a time? Are you going to rotate the teams? Perhaps you have 50% of your workers in on even in odd days in order to limit how many people are working elbow to elbow. Or are you going to bring them back by department or by seniority? Well, if you've got a collective bargaining agreement, you're probably going to want to look at seniority. Or is it going to be by the business needs, which would probably be your preference if you don't have to do it by seniority in a collective bargaining agreement. So the who that is selected will be key to discrimination claims. But you have to be careful not to do a disparate impact analysis on your own. Just like when you lay employees off, you shouldn't be then gathering the information and looking at it and deciding, well, this seems to be affecting the older workers more than the younger workers. So let's keep a few of the older workers and get rid of some of the younger workers. There's a case right on point. It's Matrix versus Amoco Oil. The court said that by doing that, although their hearts were in the right places, they want to make sure that they didn't accidentally affect one group more than another, that they actually committed age discrimination because they were basing their decisions back on age. So if you're going to do this kind of disparate impact analysis, which you probably should, that information should be done with your attorney so that you're sending raw data to the attorney who can then provide you with legal advice. And that way, those kind of things are privileged. Target did something interesting back in March. They sent everyone home right away who was 65 and older. I'm not sure if they also included people with underlying health conditions. Told them that they'll receive full pay during this stay-at-home period, and kept the younger workers. In Michigan, discrimination based on age is unlawful. It's not just discrimination against the older worker, it's discrimination against the younger workers. So this could result in some interesting lawsuits. So you also need to document which employees you have asked back and what the responses are. So I would suggest sending a letter out. You have a form letter, you can fill it in, saying when they're supposed to report back to work, where, what time, date, so on, and to who, and then have their response at the bottom, I accept it and I'll be back, or I reject it and I won't be back, and have them sign and date and return it to you. And that will be helpful for you for some of those federal loan programs and unemployment issues. What if an employee just doesn't want to return to work because of a general fear, or maybe they like unemployment? Well, too bad. Their refusal should be documented. But if they have a specific medical condition, not just being anxious about returning to the workplace, like COPD or something, then you need to consider any right to a leave of absence they may have. So you're going to have to run through the analysis. Is the COPD keeping them from coming back? That condition itself, not that plus the virus. So maybe they have rights under FEMLA to take a leave, or maybe they will have rights under the new 2 federal laws, or maybe they haven't used all their paid medical leave act time up this year yet. So there may be a right to stay away from the workplace. These kind of decisions, quite frankly, should be made in conjunction with legal counsel. So pick up the phone and save yourself some grief. What about a work share? For example, maybe you're going to bring back everybody, but only at 50% of their time, and allow them to draw unemployment for the other 50%. Or maybe you could recall everyone, but assign office days on even or odd days so that the workspace isn't so crowded. So these are just some of the things that you may want to consider before deciding how to bring people back. You don't have to bring them back all at once. You have a lot of flexibility in this. But again, I think it's a good idea to figure out what it is you want to do, and then pick up the phone and just call us and make sure that you're not stepping in something that you don't want to. Next slide, and back to Laura.
Thanks, Claudia. So what types of policies should you create before you reopen? This is a landmine, as you might expect in I just want to give you some awareness of the types of things you consider. There's so much out there that it would be probably a couple webinars on their own. Some of it Claudia touched on and some Courtney touched on. One primary one that you're going to have to deal with right away is access control, the daily symptom questionnaires, the on-site temperature checks, how you're going to handle testing, intake for visitors, and guidelines for deliveries going both ways. The next area is the social distancing. Claudia talked about ideas for in the office. The third area is sanitation and hygiene. You know, how are you going to provide frequent disinfection and cleaning of your facilities and equipment? Consider your ventilation issues. I saw something interesting today that one state did a study on, they reopened restaurants and they had a diagram and showed the tables and showed where an individual who was affected with COVID-19 sat and then where it was spread to, and they determined that airflow was the biggest factor. People equidistant in a different airflow pattern, no one got sick, and the people in the direct airflow got sick. So that's something to consider in your office spaces, again, if you have control over it. You know, availability of hand washing facilities, the restrictions on sharing tooling, machinery, office equipment, etc., to the extent you can. The fourth area is personal protection equipment. You need to consider what needs to be worn, who needs to wear it, who needs to provide it, masks, gloves, face shields, gowns if you're in the healthcare industry, those types of things. You also should be considering coming up with contract tracing procedures. Most health departments will do this for you, but you may need to do it within your own facility. If someone comes to you, you determine, you know, you have to have an isolation protocol for the person who is exhibiting symptoms or tested positive after having been in the workplace. The notification protocols, who they're going to talk to, HR, first responders, health department need to know those things. Standards for investigating, facility cleaning, shutdown procedure, and quarantine and return to work guidelines. You could also consider updating your remote work policy if you have one, and if you don't, coming up with one, reinforcing your no harassment bullying policies as people return to work, creating a business continuity policy, reviewing your benefit policies and the impact that this has had on them, and how you want to handle the return to work. It kind of ties in with, could you prohibit employees from using accrued and available vacation PTO for a period of time after you reopen? Yes, you can for vacation or personal time. You'd have to be very careful denying someone sick time or sick leave that they have. You have to consider the expanded FMLA leave, regular FMLA, the Michigan Paid Medical Leave Act. That time is separate from the federal Paid Sick Leave Act. So if someone needs time off for one of the reasons allowable under that act, you're not going to be able to prohibit the use of it in most circumstances. But if you want to prohibit vacation or PTO time for a period of time, that is okay as long as you do it across the board. You can't pick and choose because of the potential for disparate impact. Can you adjust employee wages temporarily due to the current economic condition and uncertainty? This is a question we've been getting almost from day one. And obviously people are looking at the same issue as they're starting to think about bringing people back from furloughs and layoffs. The answer is yes, with a caution. For hourly employees, for any type of employee, you can do it going forward. Basically, I hate to use the word contract, but you're basically having a new agreement with the employee as to what their wages will be going forward for a period of time. And if they don't like it, they don't have to come back to work. But as long as you've paid them what you've promised them in the past up to date, then you can change it going forward. With exempt employees, you have to be very careful. The law does allow an employer to adjust exempt employees' salaries when there are in times of business necessity, and the Department of Labor has said that the COVID-19 circumstances may justify a reduction in exempt employee salaries. There are a couple of things to be aware of that if you do that. One, it can't be a moving target. You could have done it once at the start of this or once when you bring people back, and it can be for a period of time, and then you need to bump it back up to where it was or the new normal, whatever that'll be. And again, it has to be going forward. It can't be from the point you tell the employee. You can't post-date it. And if you have exempt employees whose salary you want to reduce, it still has to be above the $684 minimum salary basis under the Fair Labor Standards Act. There's no proration allowed. Even part-time employees can only be exempt if they get a salary at that level. And so if you're reducing salaries of exempt employees, you can do it. It can't be, it's kind of a one-time thing and then a one-time change at the end of this, and it has to be for documented business necessity. So you're going to want to have some notes to yourself as to why you did it, i.e., their clients fell off, patient visits fell off, whatever it is, to justify doing it. And you have to make sure it's above the minimum salary basis amount to be able to do it. Next slide, please. And I think I'm turning it back over to Claudia.
Yeah, we're going to run through this really quick. What do you do with employees who want to stay at home, but can you order them back to work? Absolutely, unless they have some right to take a leave of absence under any of the applicable laws. What about an employee who traditionally worked in the office? Can you now force them to work at home? Generally, yes, although there may be concerns under collective bargaining agreement, for example, or if the employee has a disability that may require them to be closely supervised for productivity reasons, you may not be able to force them to be at home. What if the employee is making more on unemployment, doesn't want to come back? Too bad. Have them decline in writing and forward the response to the unemployment agency. Next slide. We're not covered by the new federal laws, so the questions are, what about an employee who's scared to come back to work? Basically, they have to return if it's just fair. What if they want to watch these, by the way, these are questions submitted by attendees. What if you have someone who wants to stay home because of child care obligations? I'm not really sure what that means, but if you're not covered under the Family First Act and it's a healthy kid, then there's no rights. On the other hand, if it's a sick kid, then you may have rights to be off work under the Family Medical Leave Act. What about the employee who's in a vulnerable population? If it's just an age issue and they want to stay home, of course you have to, there's probably no rights. If there's an underlying disability, then we're back to, does that condition interfere with their ability to perform their work, or is it an issue of a direct threat? Remember, there may be leave rights you created in your handbook if it's not written correctly, or in the collective bargaining agreement. Next slide.
Okay,
so over to Courtney.
Yes. So wrapping this up with some of the final FAQs that we got, and we did run over 1 o'clock, so I just want to thank everybody for hanging on with us, but there's so much content that it's hard to cram it all into an hour, and we will stay on for some time afterwards. That's fine with Laura, Claudia, and myself, and this will be recorded if somebody has to jump off and wants to listen to it later. But to answer some of the exposure questions, so the workers' compensation claim, as Claudia mentioned, there has already been an amendment as it relates to Michigan workers' comp law, which provides that there's a presumption that it was work-related for certain healthcare and first responders. Okay, so in other states and in other areas, we've seen that expanded to grocery workers or retail workers in some essential workforces that have been in constant contact with the population. There is not a general presumption right now in the state of Michigan for all employers that if somebody becomes COVID-19 positive, it's because they were at work. So there will probably be workers' comp claims, and then there will be detailed analyses necessarily done as it relates to the employees tracing where they were at, who else they became exposed to, and whether it was work related. So it's not an easy yes or no question right now, unless you're in that healthcare entity and dealing with the first responder analysis. What if you can't get PPE and you want to reopen? So you have business needs, you've ordered a bunch of masks, they're not in. So the executive order says that you need to provide facial coverings the best you can, basically, right? So it doesn't have to necessarily be a medical grade mask if you can't get one right now, but you have to provide some sort of facial covering, some sort of mask for employees that can wear them in the workplace that don't have a medical issue that would preclude them from using the mask. So what we're telling people is to do the best you can, get as much as you can, explore unusual options. You know, I hate to say Etsy and things like that, but we've seen employers that have some luck trying to find some unique solutions to get PPE in the door. Again, you're going to have to do the best you can as the situation continues to evolve. If you have employees that are not wearing masks because of medical issues, I would tell them, generally, this is one thing I want to touch on before we close it up. If you're reopening and you have hundreds of employees and you're telling all of your employees you have to wear masks, expect to get employees that don't want to do it for one reason or the other. Asthma, COPD, mental health issues, they have panic attacks, they have claustrophobia. So I would talk to your fellow executives, fellow members of management, and figure out what are we going to do as far as verifying this. Are we going to require doctor's notes if we have an employee that says they have a medical issue? How are we going to sort of try to stop this? Because there is the potential for a slippery slope with people not wanting to wear masks. So figure out what you're going to require. I see no issue if somebody's coming to you and they say, I need an amendment to this workplace policy because of a disability, to follow your standard interactive process, make sure that it's documented, and make sure that it's consistent and you're not just targeting one percentage of your population. So those are the FAQs that we got already that we wanted to address. Hopefully that addresses most of the attendees' FAQs. John is on the line if there were some unique questions that came in. And like I said, we're more than happy to follow up with you all via email if there was something that you would like to ask and did not get a chance to today.
Thanks, Courtney. There are a number of questions in the queue. I'll try to run through them. Some of them touch on topics we've discussed, but there are a couple here that might be a little unique. So the first one is in that category, and the question is, we're hearing that we should have waivers signed by guests and employees releasing the company from liability if, in fact, someone's inadvertently exposed to COVID-19 in their building. Is this a fact? Is this, in fact, a requirement?
No. There's no requirement under Michigan law, under federal law, that you get people to sign waivers. I mean, I don't even know if those waivers are going to be enforceable. So this is something I've seen. I'll let Claudia and Laura chime in, but I've seen some of these waivers where I'm waiving the company from any and all negligence actions, anything at all related to my appearance on the premises. I don't know if those are going to hold up in a court one day. I don't know how you could possibly waive a future event and have it be enforceable when it's something like this, and how the company can disclaim effectively any and all liability. Now, I have no issue with general disclaimers or assumption of risk notices. So things like signs or postings or disclaimers that say, by coming onto this premise, I understand that I'm putting myself in a place of exposure due to the highly contagious and novel coronavirus. An explanation like that is perfectly fine. But as far as requiring a broad waiver and release, I wouldn't tell you that it's required or necessarily that it will even be effective at some point down the line.
Yeah, I agree with
Great.
Courtney. Yeah,
I don't think it'd be effective.
I don't even think it's necessary. I mean, everybody knows when you run up to Meijer and go grocery shopping, you're assuming some risk. So, as a practical matter, you don't need to have someone sign it. I mean, duh.
Right.
Okay, great. Just as a reminder, go ahead and type into the questions widget. If you do have a question, now's the time to do it. We have a couple more to get to. Here's a question asking about best practices. And the question is, how best is it to track the acknowledgement of training? Signed documents, statements, electronic acknowledgements, those sorts of things. What's the best practice for documenting training?
I think you just follow whatever practice you've already done. However, when you do your sexual harassment training, have everybody sign in that they attended it, or have them sign a separate acknowledgement that you can put in their personnel file.
Yeah, and right now we're doing a lot of Zoom trainings. I did one this morning, so we get that. You're not always going to have people in person that can sign a handwritten document. I guess I'm old-fashioned. I always like those handwritten signatures because it's really hard for people to contest that it was them. But with that said, electronic signatures are the wave of the future, and most companies are using them to acknowledge training and that training was actually completed. So I would just make sure that there's some way of doing it, whether it's electronic or an in-person acknowledgement. You want to make sure that it's documented, the time, the date, and the subjects covered.
Perfect. This question has to do with someone taking care of somebody at home with COVID, or a high-risk person, actually. What if staff refuse to return based on a family member who is high risk in their home?
So I will chime in, and then I'll let Claudia or Laura jump on as well. So the FMLA provides protected leave to individuals who have to take care of a family member with a serious health condition. Outside of that, the Families First Coronavirus Response Act provides for up to 80 hours of leave for somebody who has been quarantined because somebody close to them presumably is sick, or because they have to take care of somebody who's quarantined. So that's a maximum of 80 hours under the Emergency Paid Sick Leave Act, which applies to employers with less than 500 employees. Outside of that potential provision of leave, we do get that where somebody says, I live with my mom, she's got COPD, she's 70, I don't feel comfortable leaving the house, coming to work, and coming back home. If there's not the application of that emergency paid sick leave time because they're not actually taking care of the person, and if they don't need leave because it's covered under the FMLA, then I don't see any way that they're protected by applicable law. And unfortunately, it's a tough situation, but we all have somebody that we're coming home to for the most part that we risk exposing. So again, I would say consider the EPSLA and the FMLA, and if those two things don't come into play, I would follow your standard policies and procedures.
Great. This next question is about flexible work arrangements, and if a flexible work arrangement continues, does the employer have a responsibility to provide furniture or ergonomic analysis of workspace?
Well,
No.
yeah. I mean, if you've got an employee who's working at a desk at home, and that person is going to be working from home, you've got an obligation to make sure that space, if they have a doctor's note, some kind of maybe a back problem or something where they have to have a special chair or something. But yeah, I mean, it's their new workspace. I'm not saying you have to outfit their office and get them, really nice desks and stuff like that. But there's a medical reason, and they get a doctor's note. It's their new workspace.
Yep, I wouldn't tell you. So I guess I interpreted the question as, do you have to go and do an initial assessment of the workspaces? No. But if you have an employee, and we've seen this, employees that have written in and said, I'm working from home and my laptop screen is too small because I have an eyesight issue beyond just I wear contacts, right? Something, a serious eye problem that requires a bigger screen. We have seen the back issue with chairs and things like that. So you would assess it the same you would as any other request for accommodation.
Perfect. Here's a quick question, I think. When someone refuses to return to work, do you terminate their employment immediately?
If there's no medical reason that prevents them, I would. It depends on,
and I would explain it in writing.
Some kind of a medical slip.
Right. If somebody just says, I'm not coming to work, you guys are stupid for making me come back, which I'm sure some of us have heard that. I've already had clients with those type of responses. I would explain, you were called back to work on May 12th. You indicated that you felt that it was stupid for us to return you to work. Therefore, your employment is being terminated because you've indicated that you're not coming back. That's a different scenario than somebody that's saying, I'm concerned because I'm asthmatic, and then just turning around and terminating them. So fact situation, but yeah, I don't see any need for it to continue. No matter what you do, make sure you confirm it in writing. The last thing you want is Casper, the not so friendly employee, which is the person who says they're not coming back to work to a supervisor. The supervisor doesn't do anything with it, and then 2 months later you realize this guy's still on the payroll, not making money, but nevertheless still sitting there. He's never been told that he was fired, that he was viewed as not coming back to work and violating the policies. So please make sure you follow up accordingly in writing when that happens.
This is kind of a job assessment question about essential employees. Any thoughts on outside sales personnel for those companies that are reopening? Are they essential, quote unquote? If so, can you require their use of PPE in the course of their duties?
I want to jump in here for
Yeah.
one thing on that topic. Currently, be very careful that you are not allowing your outside salespeople working from home to work overtime, because they, while working at home, are not exempt. If outside salespeople are not actually out and about there, they are considered working from an office, even if it's their home office, and they would be eligible for overtime. Sorry, just wanted to throw that in there.
Yeah, and this is the thing, is that what is essential is a very amorphous concept. So currently we have in the executive order a list of critical infrastructures, which is borrowed from federal guidance, okay? So that tells us who are the critical infrastructure workers that have been deemed quote unquote essential. And then beyond that, we have the resumed business activities. And then beyond that, we have employees who are necessary to conduct minimum basic business operations, basically people who pay the bills, keep the inventory in check, handle safety and security. So whether that employee is essential to your business is going to be a business specific analysis. What task are they performing? Is it part of the supply chain? Without that person, can you get the orders out? Can you get the information to your clients? Can you get the materials to your clients that might then need to put them in the supply chain? So I can't tell you white or black right now, but I can tell you that there's an analysis that could be conducted to reach that decision.
Okay, great. There are a couple more questions, but yeah, go ahead.
Oh, sorry. Last thing, the mask. I didn't want to forget your mask question. Should you have outside salespeople wear masks? I would say yes. Okay, so the order right now requires businesses to have employees who are conducting in-person work wear masks. So if they're going to another business, I would view that as in-person work. They're not sitting in their house. And I also think it goes a long way with customers and clients. Obviously, some people are very opposed to the mask, but other people believe that they're necessary and they buy in, and it provides a sense of comfort. So if you're putting your employees in that position, I would require them to wear masks.
Perfect. I was just going to say we're well over our time now, and there are just a couple more questions, but we could probably circle back with the folks that asked them directly and get those answered. Some of them are in some repetitive areas, so I don't want to take any more time at this point. I think it's probably a good point at which we could stop and wrap up things, if that's all right. So
Absolutely.
We'll do that right now. I just want to go ahead. I just want to let everybody know that when you log off, you'll get a quick survey from us. Please take a second to fill that out. We'd love to get that feedback, and we use it for our upcoming events. This program is being recorded, I should say, and you can look back on it, review it at a later date, or you can share the link with colleagues if they weren't able to be with us. So that event page is part of our website, plunkett-cooney.com. I invite everybody to check that out and take a look at the Back to Work webinar page. There'll be 2 links there for you to share. We're also going to have our Sophisticated Employer webinar series continuing on into the summer. June 11th is our next event. We're calling it Don't Take the Clickbait. It's going to be an important update about effective social media use for employers, so we hope you join us for that. We'll start to send out invitations soon for that program. And as always, I'd like to put a plug in for our Sophisticated Employer blog. This practice group does a really nice job of putting out regular content to our clients and our friends of the firm. So please, if you don't do it currently, add your email address to the area there on the blog, and you'll get updates or alerts about updates as they are shared on the blog. So our Sophisticated Employer blog is there for you as well. And really, that's all we have for you today. We want you to stay healthy, have a great rest of the day, and we'll look forward to seeing you down the road at our next event. And on behalf of Claudia, Laura, and Courtney, thanks so much for being part of our program, and we'll see you next time.